Next, reaction from Capitol Hill on the Supreme Court decision. Senate Judiciary Chairman Arlen Specter talks about legislation he'll be offering on the military tribunals. His remarks are about 20 minutes.
The senator from Pennsylvania is recognized.
Mr. President, I have sought recognition to discuss the case of Hamdan versus Rumsfeld, which was decided by the Supreme Court of the United States today, and to address the question as to where we go from here. There have already been many inquiries as to what is the import of this Supreme Court decision and what are the next steps in order to establish a framework to deal with the people who are detained at Guantanamo Bay. Since the opinions were released this morning, my staff and I have been reviewing them, 177 pages, 6 opinions. The essence of the decision of the Supreme Court of the United States on a 6-3 vote is that the President did not have the authority to establish the military commissions, and that the authority rests with the Congress under the Constitution. The court dealt with the issue of the resolution authorizing the use of military force, a resolution which the administration has sought as authority for amending the Foreign Intelligence Surveillance Act. And when the court dealt with the resolution authorizing the use of military force, the court said that that did not give the President the authority to establish the military commissions. The court did not deal with any issue of inherent authority, but obvious from the decision that the President lacked the authority to establish the military commissions is the conclusion that there is no inherent authority, an inference and a proposition which may have some weight as we consider collateral matters, for example, on the electronic surveillance under NSA. The Constitution of the United States is explicit in Article 1, Section 8, which states, and I'm leaving out some of the irrelevant language, Congress has the authority, quote, to make rules concerning captures on land and water. So it is a congressional matter. In reaching its conclusion, the Supreme Court of the United States found that the military commissions violated the Code of Military Justice and also violated the terms of the Geneva Convention. The court found that the military commissions violated the Code of Military Justice because they did not provide for very basic due process considerations. The court said that the military commissions violated the Geneva Conventions, which the court found applicable, reversing the Court of Appeals for the District of Columbia, where the Supreme Court said the Geneva Convention, Common Article 3, plainly affords some minimal protection to individuals associated with neither a signatory nor even a non-signatory who are involved in a conflict. The court dealt with the issue of jurisdiction by saying that the government contention that the Supreme Court had no jurisdiction was wrong. The Supreme Court referred to the provision of the Detainee Treatment Act of 2005, which provides, quote, no court shall have jurisdiction to hear or consider an application for habeas corpus filed by an alien detained at Guantanamo Bay, was a reference to the statutory provision which gave exclusive jurisdiction according to the statute to the District of Columbia Court. The statute provided specifically the United States Court of Appeals for the District of Columbia Circuit shall have exclusive jurisdiction to determine the validity of any final decision of a combatant status review tribunal that an alien is properly detained as an enemy combatant. I argued as forcefully as I could when that amendment was considered that it was searching for the right word. It was really atrocious, without any hearings, without any extended floor debate. And I had 2 minutes to speak under the rules of governing the amendment that we would be taking away jurisdiction of the federal courts except for the District of Columbia. Now, on its face, that language would say that the Supreme Court of the United States had no jurisdiction. Well, the Supreme Court made short shrift of that point, saying that it did have jurisdiction. When you deal with a constitutional issue, it is hard for this lawyer to understand how you can take away jurisdiction from the Supreme Court of the United States. How can you do that when we know since Marbury versus Madison in 1803 that the Supreme Court of the United States is the final arbiter of the Constitution? But this language, this clumsy language, sought to vest exclusive jurisdiction in the Court of Appeals for the District of Columbia. Well, the Supreme Court made short shrift of that. But on a personal note, and relevant to this consideration as well, in Justice Scalia's dissent, he cites my floor argument in a footnote saying, quote, at page 12 of his opinion, quote, an earlier part of the amendment provides that no court, justice, or judge shall have jurisdiction to consider the application for writ of habeas corpus. Under the language of exclusive jurisdiction in the D.C. Circuit, the U.S. Supreme Court would not have jurisdiction to hear the Hamdan case. It at Senate Congressional Record 12796, parenthesis, statement of Senator Specter, close parenthesis. Interesting that Justice Scalia, who doesn't believe in congressional intent or congressional deliberation, would make that citation. But when I made that point, that the statute on its face took away jurisdiction from the Supreme Court of the United States, I made it plain that I did not think it had any validity. Couldn't do that. What the statute really was trying to do, in part, was to look to a favorable court. The D.C. Circuit was a favorable court, a little court shop, and there was an effort to take away the jurisdiction of the district court from habeas corpus proceedings. Well, under the logic of Hamdan, where you have a statutory provision that the D.C. Circuit has sole jurisdiction, the Supreme Court reads that and not to take away jurisdiction of the Supreme Court. Inferentially, the same conclusion would follow for the district court. It doesn't say the district court doesn't have jurisdiction, just like it doesn't say the Supreme Court doesn't have jurisdiction. It just says exclusive jurisdiction is in the D.C. Circuit. A little hard to see how that would work out if you file a petition for writ of habeas corpus in the D.C. Circuit. It would be anomalous. Those petitions are filed in the district court. But at any rate, the Supreme Court of the United States took jurisdiction of the case and found that the procedures which the administration has prescribed do not comport with law.